Welcome to day two. The 89th Texas Legislature enacted significant reforms aimed at strengthening mental health infrastructure and services for individuals with intellectual and developmental disabilities. Texas Tech Law Professor Shannon and HHSC Associate Commissioner of Mental Health Programs Reilly Webb will share insights into these latest legislative reforms, including funding priorities and statutory changes affecting the courts and mental health systems. Professor Shannon.
Thanks, Judge, and I've got a lot of mics, so I will probably move about a little bit. Welcome, glad you're here. Let's get everybody's juices flowing besides just on coffee. Good morning. Yeah, any Red Raiders in the house? Wreck 'em, okay. Now that we have that out of the way, I want to highlight, well, first off, Reilly and I are going to split about 20 minutes each. So I'm going to talk first about some of the substantive proposals. Reilly's going to talk about the dollars. So this was the third legislative session for the JSMH in terms of making formal recommendations to the Texas Judicial Council and having legislation move forward. So I want to highlight both some civil recommendations we had in criminal. The outcome was that the civil were enacted in part. The criminal provisions, unfortunately, did well until they didn't. They stalled on the House floor. So we'll talk about those in a bit. First, on the civil side, as you heard yesterday in some of the opening remarks, Senate Bill 1164 that Senator Zaffirini carried was enacted, and there were four main areas that were passed that I'll highlight. One relates to modifications to peace officer emergency detention forms to better elicit information that would be helpful once the person is taken to the inpatient mental health facility. There were also clarifications to law enforcement's duties upon presenting the person without having a warrant. A venue provision was part of it, and then attempting, and how many of you were with us 2 years ago at the symposium in Galveston when we heard from Dr. Amador? Well, one of the things he talked about, if you'll recall, is the common symptom of anosognosia that is present in many individuals with schizophrenia and some with bipolar disorder, this lack of insight. And so we had some proposals trying to address that and make that something that officers could take into account. The emergency detention form, obviously this is too small for you to see. One of our goals was to keep it at 2 pages, but you'll see, and the reason I put it on the screen, more blanks, more boxes, places where law enforcement, as they are taking the person who's apprehended, who's in need of emergency mental health services, to have some explanation of what's there to help the practitioners once they get to the mental health facility. And so after the session, JSMH, through Kama Harris's leadership from the staff, the forms committee was working on this, and I think we're pretty happy with where the form is. It is now, as you heard from Justice Bland yesterday, with the Supreme Court, they have the final say on forms, and so it's in their hands whether to approve it or to recommend any further changes. But this is already out, and officers are being trained on use of this form and some of the issues with the new law. JSMH is also, through some of you who are here in this room, have been putting together a video for training officers in both use of the new form as well as some of the changes in the standard that I'll show shortly. So one of the provisions relates to the law enforcement officer's duties when transporting the person on a warrantless emergency detention. 2 years ago, in the prior session, JSMH had recommended legislation, really at the behest of law enforcement, that once the person has been taken to the appropriate facility and the paperwork is filled out, they ought to be able to depart and get back on the street and doing the things we want law enforcement to do. The bill that passed 2 years ago addressed that for magistrate warrant situations. So when a judge or magistrate issues a warrant, those officers who go and pick up the person and transport them subject to the warrant had this measure passed with respect to their obligations to stay or not stay when they delivered the person to the appropriate facility. This then picked up the other piece when we have an emergency detention without a warrant. Now, a few words on that and thinking about it, they're not required to remain, and they may leave once they've completed the appropriate paperwork, but leave where? And where are they taking? And it's something important, I think, to note, and there's been a little confusion on this since this passed, is throughout it talks about somebody who's transporting the apprehended person to a facility, and you see I circled the word facility every place it shows up. Well, that's the new language. Nothing was changed to subsection 1D, which defines facility for purposes of 573.001, and that defines facility as the nearest appropriate inpatient mental health facility, or a mental health facility designated by the local mental health authority. So think about what that might not include. It might not include an emergency room at a general hospital that doesn't have a segregated part of that facility for psychiatric beds. There still needs to be local cooperation with respect to steps that are taken if somebody needs to be medically cleared. And recently we had, and you heard Christy Taylor talk about it, emergency detention roundtable to talk through some of those issues and learned quite a bit about how different counties, different parts of the state are handling that and dealing with that. And I'm not sure a lot of that could be captured well in any further statutory changes, but it's fairly important that there be local conversations, local policies put into play. So venue, another bill that passed, there had been some concerns, and this legislation had been introduced in the session 2 years ago and didn't pass. JSMH was asked to make it part of our package this time, and we did, and it did pass this time. Issues come up, say somebody is apprehended on emergency detention in, for example, Arlington, Texas, in Arlington County, but they're transported to Parkland Hospital in Dallas. Well, what's the appropriate venue? The statute used to say, well, it's where the person is found. Well, were they found at the time they were apprehended in Arlington County, or were they found later once the application is filed when they're at Parkland? And there had been some disputes between counties about that. Star Care, where I'm privileged to serve on the board, we've got 4 more rural counties outside of Lubbock County, and same thing. Say a Texas Tech student is having a mental health crisis in Hockley County and is transported to our Sunrise Canyon Hospital in Lubbock County. Well, proper venue might be the young person's county of residence, and then you'd have this issue about, well, where were they found? This statute just says, hey, either one. Either one. It can be the county where they're located at the time the application is filed, or the county where the person was apprehended under the emergency detention, to try and clarify some of the disputes that were related to that. With respect to the criteria for emergency detentions, for both warrantless apprehensions as well as applications where a magistrate signs, the standard has changed. This is some of the language that's now present. The law had been where emergency detention could be pursued if the person was suspected of having a mental illness and was a danger to self or others, or was exhibiting severe emotional distress and deterioration in their condition such that immediate action was necessary in the officer's view, or the magistrate's view if it was an application for warrant. The expansion here is what you see there in subsection C, where the person may evidence an inability to recognize symptoms or appreciate the risks and benefits of treatment, and there's some immediate need to act. So trying to identify persons who are suspected of having a mental illness, as well as not recognizing some of the issues that are there. Now, the way this is structured, some have said, well, it looks like you've added something here about deterioration. No, it was just in a different subsection of the statute previously, but that had been there. Subsection C is the newer language. We also attempted to change the civil commitment standards for both inpatient temporary and inpatient extended by adding a fourth alternative prong. It might help to add some little circles there. Sorry, the font is smaller. It's just my old eyes. Currently, the civil commitment standards for inpatient, you're familiar with, there's 3 alternative prongs: dangerous to self, dangerousness to others, or the so-called deterioration language, the 3 subparts that are set out in subsection C. What we proposed, and the bill as filed, would have added a fourth related to the anosognosia types of issues: lack of capacity, lack of insight. So a fourth alternative, and you see I put a little circle around the word or, so adding that. Through the legislative process, though, what passed kind of got it messed up. And this next slide, I want to thank Chris Lopez. This is something he put together after the session. Notice where the language that's there showing as little 4, it's not a separate alternative. Instead of having danger of self, danger to others, deterioration, or this lack of capacity, it was mushed in, that's a legal term, mushed in with what is known as the deterioration provision. And so instead of having 1, 2, 3, or 4, this fourth was put there. Plus, up there at the top, unfortunately, an or got taken out, an and was added later. That can matter. If you really parse through this and read it carefully, as passed, this would have appeared for any inpatient civil commitment to require a showing of everything: dangerous to self, dangerous to others, deterioration, lack of capacity, all of it. Well, that's not what anybody intended. That's not what anybody intended. And happily, there was a called special session. Well, 2 called special sessions. And Christy and our committee, we were able to work with Megan Lavoie at the Office of Court Administration, and with the good graces of the Chief Justice, we found a vehicle, the HB 16, which was the omnibus judicial bill that included the pay raise for those of you who are judges. Pretty good idea that, although it had been vetoed in the regular session, those issues were fixed and that it was going to pass. And we asked permission to tack on some language that would, in effect, just undo what had been done with those subsections. Not the emergency detention language, but the errors that had unfortunately and inadvertently been included with respect to civil commitment language. So as of September 1, the wrong language became effective. As of September, 16, 17, when the governor signed HB 16, it had immediate effect, and we were back to the civil commitment standards that you know and that have been in play. And we will try and work on, between now and the next session, if it's the will of the Legislative Committee and the full commission, whether to try again with respect to adding a fourth alternative prong or not. I do want to spend a little bit of time on the language that didn't pass. Sometimes you ask, well, what happened with the bill? Was there big opposition? For our criminal-related proposals, they were all packaged in a bill that went before the House Criminal Justice Committee, Chairman Smithy's committee, had no opposition raised at the hearing. It passed out of committee nearly unanimously. There was one no vote in committee, but it passed. It moved on to the calendars committee, came out of calendars, and the last week within the session where bills originating in the House that could be heard on the floor, it got to the floor on Monday. By the last day later that week, it was still on the floor. That very last day, there were 400 bills that were before the House. 200 of them passed. The clock ran out. Ours was part of that group of 200 that didn't move forward. Basically ran out of time. And so a lot of these concepts we're going to urge moving forward again, because I think we had a lot of good things in there. Would have clarified AOT courts to count as specialty courts, which is important for trying to obtain initial funding. Would have confirmed jurisdiction for courts at law judges who might serve over a specialty court, that felony cases can come to them. That's typically handled by local administrative rule. This would have codified that. Some changes to law enforcement diversion plans. And I'll just pop some of what our language had included. 1623 requires diversion efforts. The law as it exists now requires that plans be put in place to divert persons to a facility. Well, some of our counties don't have a facility. And so this would change that to talk in terms of trying to get to a program that might or might not be in that county. So I think we would want to try that again. We would have expanded possible cases for JBCR, jail-based competency restoration. Right now, subsection 46B.091 is limited to largely nonviolent type offenses. Our friends in Tarrant County had made a recommendation, well, why should we limit that? Jail's a pretty secure place. If the local jail-based competency restoration program thinks that they could serve a person in jail-based competency restoration safely, they should have that discretion. So this would have looked at opening up and broadening these that could be considered. In addition, some what we think are needed tweaks and changes to Chapter 46B on competency restoration, trying to limit inpatient competency restoration as applied to nonviolent, low-level misdemeanors. Adding some procedures to address what happens when somebody comes back from the state hospital and then decompensates prior to the case being resolved. There's very little in 46B.084 to speak to that, and prosecutors and defense lawyers are sort of left having to guess, because you can't constitutionally try the person if they've deteriorated. There's just not much there with respect to process. Authorizing a possible step down to community-based services for defendants with IDD who have been found, in effect, incompetent and likely not restorable. We have that on the mental health side with a possible step down to outpatient types of oversight. This would have created a parallel on the IDD side. And then one, kind of my favorite, how many of you, if you had to come up here right now and give a great definition of foreseeable future, would do a good job? I see in my foreseeable future that I'm supposed to stop talking about a minute and a half. But beyond that, I couldn't give a good definition. And so we have tried this the last couple of sessions. We'll try again, saying, hey, doc, do you think this person can be restored in the period allowed by the statute? With a felony, that would be 120 days with one 60-day extension. A lot easier than just saying, well, what's foreseeable future? With a misdemeanor, 60 days and one possible 60-day extension. We'd also look at trying to create a mechanism for a dismissal of a Class C if it appears the person lacks capacity. Because it's a Class C, 46B doesn't apply to that person. Yet, constitutionally, that person shouldn't be tried if they're not competent. Trying to expand who can apply and testify in medication proceedings. Those are the other two. Here is the language we were attempting to push through on the Class Cs. And then with medication, trying to expand this not to just be a physician or psychiatrist, but to extend to medical extenders, psychiatric nurse practitioners, physicians assistants who are specialized in psychiatry, because many of our rural counties can't get the docs to be able to readily proceed in these areas. So, couple of things else, not a JSMH bill, but a different bill, HB 305. When somebody comes back from competency restoration, this was trying to just move the cases, to have some kind of pretrial hearing. Don't study it, the governor vetoed it. Some good ideas there, but it's not the law. Another that I was watching was and I'm sure HHSC was watching, Reilly was watching, because the money aspects, HB 1461 passed in the House, died in the Senate. It would have said, hey, if somebody's still waiting after 45 days and hasn't been given a state hospital bed, the state's going to have to reimburse the county for any day after that in terms of costs. Yeah, big dollar item. Let me finish with this. The work is going to start soon, looking ahead to the next session. I think we've got a good start because we can take a lot of these criminal-related concepts and try and pick up the ball and run with it again. Some lessons learned, we need to think about how we can best work together. Christy and her team, great staff, small staff, can't really lobby, can only educate. But many of you, for example, JPs, municipal court judges, district county judges, while you might not be able to lobby directly to, you've got representatives who you might be able to educate and inform. And when a bill like our bill is on the House floor, some calls to the speaker's aides as far as, hey, this is good legislation, we got to work it through. So let's work together, go forward, and I'm out of time. I'm going to hand it off to Reilly.
Good morning, everyone. My name is Reilly Webb. I serve as the Associate Commissioner for Mental Health Programs at Texas Health and Human Services Commission. Thank you, Professor Shannon, for that wonderful overview of legislative updates. My presentation is mostly going to focus on probably budget updates. I will touch on a couple of bills that were of interest to the agency, but mostly going through budget to give you all an idea of the types of appropriations that were passed during last session. So I want to make a plug for the Statewide Behavioral Health Coordinating Council. That council is comprised of representatives from various state agencies, institutes of higher education. It was really established to coordinate and implement statewide strategic plan for behavioral health services. But in addition, they're also tasked with developing annual coordinated statewide behavioral health expenditure proposals. And I think it's a good place to get a snapshot or an idea of the types of funding that you'll see across the General Appropriations Act for behavioral health. So looking at this chart, I will back up a little bit and just say, again, I think this is a good picture of some of the behavioral health funding that is out there in the state. Very broadly, the General Appropriations Act is the state budget that gets passed every 2 years by the Texas Legislature. It's arguably the most important legislation that gets passed in Texas because it determines how much funding is appropriated for the biennium, which is fiscal years 26 and 27. Texas Constitution requires that budget be balanced. It's really the only bill that that must pass during session. The Appropriation Act begins as HB 1 on the House side, SB 1 on the Senate side. House Appropriations Committee, Senate Finance Committee do their amendments, mark up. Those differences between the two bills are resolved during conference committee. The final bill gets sent to passed by both chambers, gets sent to the governor for signature. And it alternates every session. So if you hear SB 1, that is basically synonymous with General Appropriations Act. Next session will be HB 1 that passes. The Appropriations Act is divided into basically major functional areas of government, which is the articles that you're looking at there. Article 1 is general government. Article 2 is health and human services, so that includes HHSC. Department of Family and Protective Services, Department of State Health Services. Article 3 is education. Article 4 is the judiciary. Article 5 is public safety and criminal justice. Article 6 is natural resources. Article 8 is regulatory. So that table there gives you an idea of the members of the council in terms of the expenditures that they anticipate for the biennium. Also plug the strategic plans that the council puts forward. The 88th legislature directed the agency to develop a strategic plan for children's behavioral health. That was published December of 2024. And overall, the statewide plan for behavioral health expires this fiscal year, so planning has already begun to renew that for the next 5-year iteration. So doing a deeper dive on Article 2, within Article 2, there are basically goals within that Appropriations Act, which are broad policy areas. Most of our funding resides in Goal D, which is simply named Additional Health-Related Services. Each goal contains multiple strategies, which are basically programs or methods of funding that goal that give us performance targets for those funds that we have to use, restrictions or direction on how we can use those funds. So D21 is a community mental health strategy. You'll see that's at $1.4 billion for the biennium. D22, substance use, much less at $500 million. D23 is our behavioral health waivers, yes waiver in home and community-based services for adult mental health at $81 million. D24 is our community mental health grants. These are our matching grant programs and county-based collaboratives at $235 million for the biennium. D25 is an administrative sort of indirect cost strategy there at $150 million. And G22, goal G is a facility-based goal. So G22 is the funding that gets used for community mental health hospitals or private psychiatric beds. That's at $782 million. So for the total for the biennium, we're looking at about $1.6 billion for each fiscal year for a total of $3.2. The supplemental bill is House Bill 500. It kind of does exactly as it's named. It provides additional supplemental appropriations and gives agencies additional direction on how to spend those funds. There's some new funding. Very briefly, I'll mention a couple of things that might be of interest. Renovations to Harris County Psychiatric Center at $12.8 million. The agency received authority to extend 2 sessions ago that supplemental bill, which was Senate Bill 30. Any unexpended or unobligated balances that were there can roll over into this biennium. There was a state hospital that was under construction in El Paso, which didn't receive additional appropriations last session. So that has since transitioned to a crisis facility that'll be run by Emergence Health Network, the LMHA out there. That'll be a 32-bed crisis facility with additional jail diversion capacity. Uvalde Behavioral Health Campus received, it was under SB 30, the grant management system for the agency. That'll be really important for our contractors and for our staff to be able to administer the funds. And the Sunrise Canyon facility, which is a community psychiatric facility up in Lubbock, is expanding and has some construction funds there as well. I'll briefly touch on a couple of bills. HB 114 by Rep. Cortez essentially moved some programs from HHSC to Texas Veterans Commission. As Texas Veterans Commission grows, they really have the ability to administer these programs, and it just made sense to consolidate veteran programs over there. So we've moved mental health programs for veterans, the TVFA program, and the Suicide Prevention Action Plan over to TVC. HB 4783 by Rep. Van Dever relates to a report on governmental opioid antagonist programs. It requires a biennial report on those programs, and these are basically programs that focus on training the public and first responders on administering naloxone. The report has to include a needs assessment for those programs and establish a statewide saturation goal for naloxone distribution. HB 5342 by Rep. Landgraf established the 98 Suicide and Crisis Lifeline Trust Fund. It also directs the agency to conduct a study on looking at funding mechanisms for 988. 988 is currently 100% federally funded through HHSC. Many states have raised a fee on your wireless carrier bill or received direct appropriations for that. This study this bill sets the framework, I guess, for directing the agency to look at how we could implement and sustain 988. Senate Bill 2069 by Dean Saffarini establishes a work group to determine the feasibility of implementing a psychiatric bed registry. It charges that work group with looking at data issues for sharing information across hospitals, coming up with policy incentives to report that bed availability information, looking at technology issues. That report's due November 1st of 2027. Senate Bill 2308, the Ibogaine bill by Senator Parker, establishes a consortium to conduct FDA drug development clinical trials on Ibogaine. Ibogaine is a psychoactive compound extracted from a tree native to Central Africa. Some of y'all may have heard this in the media. It's gotten a lot of attention. Governor Perry, former Governor Perry, openly advocates for this because of the promise that it shows for opioid use disorder, trauma, any co-occurring substance use disorder. And so there's a $50 million appropriation for that. And those consortium applications are under review by the agency. So we have to submit a report to the legislature on December 1st of each year from that bill. I will close by flipping briefly back to the budget in terms of riders of interest. Budget riders are basically special provisions that are added to the General Appropriations Act that give us instructions on how funds are to be spent. For youth crisis outreach teams, there was an appropriation of $20 million per fiscal year. There was a pilot program 2 sessions ago to start that program. It was $7 million. So that program will expand to 16 total youth-specific outreach teams that are aimed to provide crisis support and services to youth and families and follow-up services to those in the community. We have to do a report on that as of actually got published September 1st of 2025. I'll mention some other riders for operational funding. Uvalde Behavioral Health Campus received some operational funding once that opens in January of 2027. Comal County's crisis facility there got some operational funding that'll be open August of 2026. For substance use rates, many of you might know that our substance use programs are basically fee-for-service contracts, and a lot of them are mom-and-pop providers, so they really live or die by the rates that get set for substance use. We were directed to look at a rate-setting methodology for children that accompany a mother to receive residential substance use services in a residential treatment setting. Lastly, I'd say there probably was not a system-wide investment in the local mental health authority system, probably arguably not since crisis redesign in 2008, but there were earmarks in the Appropriations Act for local projects in the budget that are sort of specific to certain counties. So various crisis services in specific counties got funded through dedicated riders. Certain facilities and private psychiatric beds. Legislature directed us to provide funding for inpatient competency restoration in a few counties. And overall, there was a small increase in our Healthy Community Collaborative funding, which is a grant program that we operate. That was all directed through certain riders. So with that, I think I will close and turn it back over.